Yes. Hello, I can. Hello, hello. Hello, hello.
your lawyer? Scott McKee?
No.
Okay. You can sit down.
Here. Okay, we click on it. Where the line that was crossing the microphone went.
That means they can hear you.
Okay. Yeah, that means he can hear me.
All right, they should be able to hear me on Zoom now. If not, then it's...
There it is.
I hear you.
All right, moving on. Ms. Altier.
The top of your 130 document.
Edwin Williams, come on up, sir. All right, this is cause number CR 21-0201-392, the state of Texas versus Edwin Williams, set for discovery status.
That's correct, Your Honor. As far as I know, we have all of the discovery. And we have a plea offer.
And what's the plea offer?
The offer is 30 years.
All right, 30 years. All right, and let's see, you got all the discovery you said?
Yes, I did.
And does Mr. Williams have conditions of bond?
Yes, he does, Your Honor. He said them last month. Well, 2 months ago.
All right, well then, Mr. Williams, court deems discovery status is held. Your next court date is July the 6th at 1:30. However, I'm going to order you to take a drug test today. You know the drill. You did it back in April. You'll go with probation, take the tests. When you get done, sir, come back in the courtroom. We'll go over the results together. Shiplet.
Yes, Larry Shipley. Your Honor.
Larry Shiplet. All right, this is cause number CR 21-0171-392, the state of Texas versus Larry Shiplett. And that is set for discovery status.
We have all of the discovery and we also have a plea offer from the state.
Oh, that's the TV out there that's echoing. I thought we were plugged straight into here where we didn't have a delay. It's like, I was about to tell that person to be quiet, but that person's me. You just keep it down. Sorry, Mr. Shiplett, where were we? You had an offer. What was the offer?
4 years probation.
4 years probation. All right, does he have conditions of bond?
No, it's not referenced at this point.
Let me see the document.
This is a DWI case.
I know what it is. I'm looking right at it. Is this a first time DWI just happens to be with child passenger?
That's correct.
Okay.
Your Honor.
All right, well then, Mr. Shiplett, is the indictment allege alcohol?
Yes.
Okay. All right, well then, Mr. Shiplett, then the court deems discovery status is held. Your next court date is July the 6th at 1:30, and that will be for a pretrial. So as soon as you receive your reset notice, you're free to go.
And I have nothing further this afternoon. Robert.
See. He's turning it down. Mr. Head. Ross Darby.
One of them is set for arraignment, the others are for discovery status.
I'm going to call the arraignment first. All right, it's cause number CR 21-0440-392, the state of Texas versus Cross Darby, set for arraignment. Mr. Head.
Your Honor, Mr. Darby's name does appear correctly on the indictment. He understands the nature of the charge. He waived the formal reading of the indictment and a plea of not guilty for purposes of arraignment.
All right, sir, the court notes your plea of not guilty for purposes of arraignment. On this case, your two next court dates are August the 4th for discovery status, and then again on September the 1st for pretrial, and both of those are at 9 a.m. And then now I'll call the other cases. These are cause numbers CR 21-0173, 74, 75, and 76-392. And all of these are styled the state of Texas versus Cross Darby and all set for discovery status.
And Your Honor, we have received discovery. To my knowledge, we've received everything there is. I'm not aware of anything that's missing.
And do y'all have an offer to wrap all this up? And that would be,
It's a 10-year TDC. Probated 5 years as a fine, and then on the state jails, there's a concurrent probation with
Okay.
the different cases.
alrighty then, Mr. Darby, the court deems discovery status is held in these cases, and I'm resetting these for pretrial on August the 4th at 9 a.m. as well. And so we'll see you back on all your cases on August the 4th. However, based upon the nature of the charge in the new one that you were just arraigned on, I'm ordering you to take a drug test today. You'll go with probation. Take the tests. When you get done, come back in the courtroom and we'll go over the results together. Thank you, sir.
And Mary Trahern, I'm sorry, Your Honor. For some reason, my name doesn't appear on the clerk's records, but I notified them today.
Ms. Trahern. All right, this is cause number CR 21-0161-392, the state of Texas versus Mary Trahern, set for discovery status.
Your Honor, to my knowledge, we have received the full discovery.
Nothing outstanding. And is there an offer?
Judge, there is, you just got the table.
Well, I don't know what, but I hadn't seen the offer. Okay. Yeah.
Offers to go open to the court, Your Honor.
Your Honor, I'll discuss that with Mr.
Sure.
Trahern.
That's what I'm see if there is one. All right, Ms. Trahern, then the court deems discovery status is held. Your next court date is July the 6th at 1:30 for pretrial. And so we will see you back on July 6th at 1:30. Stay in touch with Mr. Perkins and Mr. Head, and we'll see you then.
Schedule a time to get together and visit. Okay. That's all I had. I'll just wait for Mr. Darby's.
Yes, sir. Stevens.
Abraham.
Mr. De Silva, come on up. This is cause number CR 21-0206-392, the state of Texas versus Chris Abraham De Silva, and that is set for discovery status.
Your it's our understanding we've received all the discovery lists or something the state knows about that's outstanding.
Nothing outstanding, Your Honor. There's an offer, 180 days to go.
Okay. All right, then, Mr. De Silva, the court deems discovery status is held. Your next court date is July the 6th at 1:30 for pretrial. I'm going to order you to take a drug test today. You'll go with probation, take the test. When you get done, you know the drill. Come back in the courtroom. We'll go over the results together.
I'll circle back.
I signed everything they gave me. Mr. Scott.
Yes, Your Honor. Haley Holt.
Well, I gotta find it. Haley Holt. This is cause number CR 21-0226-392, the state of Texas versus Haley Holt, set for discovery status.
It is, Your Honor. We've reached an agreement for a PTI, and as part of that agreement, my client had to execute a jury waiver,
Okay,
and we've got that for the court. I think it's been signed by everybody.
all right, if you don't mind if I place your client under oath just to ask you some questions about it.
No, Your Honor.
All right, Ms. Holt, I'm going to ask you some questions strictly related to this waiver of jury and nothing else, okay? I can get you to raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God? You can lower your hand. Ms. Holt, I'm holding this document in my hand. It's waiver of jury. Are you familiar with that document?
Yes.
And did you go over it with Mr. Scott?
Mhm.
And did you understand it?
Yes.
Do you have any questions about it?
No, I do not.
Well, that document basically lets you know that, and I'll tell you that under the Texas Constitution and the United States Constitution, you cannot be held to answer for a felony if you want a jury trial without a jury trial. Do you understand that? And you're the only one that can waive that. Do you understand that? And do you know what a jury does? Okay. And do I need to explain that to you? And you know that if whatever this deal is you have worked out with the state, if that were to fall through,
Yes.
and I were to approve this, you would still have a constitutional right to a jury, to a trial, just not in front of a jury. It'd be in front, hold on, let me finish. It would just be in front of the court. Do you understand that? When you do one of these, I have to make certain findings, you understand? And so, do you want to continue on with this waiver of jury, knowing that if this deal falls through, you won't have a jury trial, you only have a bench trial? All right, and Mr. Scott, you believe your client has knowingly, intelligently, and voluntarily waived her right to trial by jury?
I do, Your Honor.
All right, when the court finds that she finds that counsel for the state has consented, and I'm signing it this the first day of June.
Thank you, Judge.
And am I resetting this anyway?
I don't believe so. My understanding is now she's going to go over to the probation department, and we won't have any more court. But this is my first one, so.
I think on the last one, I'm going to give her a reset notice anyway. That way, if something happens, we don't have to get her back on. I'm going to reset you to July the 6th for pretrial at 1:30. However, if you enter into this agreement and it's all done, you won't have to come back on that day. All right. And Mr. Scott will let you know, and so will Mr. Perkins. Once you receive that, ma'am, you're free to go.
Thank you.
Yes, ma'am.
Can I sign into the city?
Ma'am, you need to meet with probation right here. Martinez?
No, Your Honor, that's gonna be a plea, and I still need to go over the papers with my client. I have Zachary Anderson, Your Honor.
Zachary Anderson.
I haven't seen him today, Your Honor.
All right, it's cause number CR 21-0190-392, the state of Texas versus Zachary Anderson. Is there a Zachary Anderson in the courtroom? I see no one. I hear no answer. Is there a Zachary Anderson appearing via Zoom? I do not see anyone with that name. Time is now 1:58. He is not in the lobby. The docket was set for 1:30. Court will entertain a motion.
Thank you, Judge. State request bond forfeiture on this cause.
Granted, a capious will issue. He'll be held with no bond.
And Your Honor, I had a motion for withdrawal set today. I don't know how the court wants to proceed on that. He'd advised me, we had a falling out, and he'd advised me that he doesn't want me around him at all.
Maybe that's why he's not here.
Maybe,
Well, I think he has a right to be here to hear that, even though I guess we could hear it in absentia if he doesn't show up for his next setting or today.
okay,
I'm sure we'll get to him sooner or later.
yes, sir.
So we'll just keep that pending.
Thank you, Judge. And if I can be excused, I'll take care of that plea.
Yes, sir. Ms. Thompson. Christy Jones. Yes, it was a long Memorial Day. Christy Jones. It's cause number CR 21-0225-392, the state of Texas versus Christy Jones. All right, is there a Christy Jones in the courtroom? I see no one. I hear no answer. Is there a Christy Jones appearing via Zoom? I see no one. Time is now 2:00. She is not in the lobby. The docket was for 1:30. The court will entertain a motion.
Thank you, Judge. State request bond forfeiture.
Granted, capious will issue. She'll be held with no bond.
I've got Scotty Barker on page 10
For a plea,
for police.
Scotty Barker. She signed up. Thank you, ma'am. All right, this is cause number CR 21-0376-392, the state of Texas versus Scotty Barker, and set for a plea today. Is the state ready? And on behalf of Mr. Barker,
We're ready, Your Honor.
all right, sir, if you can pull that mask down the best you can. There you go. Sir, is your name Scotty Lamont Barker?
Yes, sir.
And are you the same person that was originally indicted by a Henderson County grand jury for this state jail felony offense, the possession of a controlled substance?
Yes, sir.
I can get you to raise your right hand the best you can, sir. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
You can lower your hand. Mr. Barker, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not, and you enter into this plea bargain with the state, it could have certain negative immigration consequences. Do you understand that?
Yes, sir.
And Mr. Barker, have you ever been treated for any mental health or emotional issues?
No, sir.
Do you understand what's going on in here today?
Yes, sir.
And Ms. Thompson, do you believe your client is competent?
He is competent.
The court finds that he is. The state needs to sign that. Mr. Barker, I know that we've already arraigned you on this case. However, would you like the prosecutor to read the indictment against you out loud here in the courtroom?
Read.
No,
You want him to read it or not?
No.
No, but do you understand the charge?
Yes, sir.
Well, as indicted, that charge is a state jail felony. A state jail felony carries a punishment range of not less than 180 days, nor more than 2 years in a state jail felony facility, and a fine up to $2,000. Do you understand the range of punishment?
Yes, sir.
Did I say 2,000? Up to 4,000. I don't know where I got 2,000. Up to $4,000. Do you understand the range
Yes,
of
sir, I
punishment?
do.
In the plea bargain? In the plea bargain in the case?
Oh, the state would be recommending 12 months in state jail.
Attorney's fees, court costs, and restitution DPS?
Yes, Your Honor.
All right. Is that your understanding of the plea bargain, Mr. Barker?
Yes, sir. it is.
And is that your understanding, Ms. Thompson?
It is, Your Honor.
Well, Mr. Barker, a few minutes ago, you told me you could read and write the English language.
Yes, sir.
I'm going to show you two documents, the first of which is the agreed plea recommendation. Did you read and go over both the front and back of that with Ms. Thompson?
Yes, sir, I do.
And did you sign it?
Yes, sir, I do.
Do you have any questions about it?
Yes, sir.
The next document I'm showing you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that?
Yes, sir, I do.
And did you sign the second page?
Yes, sir, I do.
Do you have any questions about it?
Yes, sir, I do.
Do you have any questions about any of the documents that you read and went over with Ms. Thompson?
Yes, sir, I don't.
Well, if you read and went over these with her, I know she explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial in this case?
No, sir, I don't.
Do you want to enter into this plea bargain?
Yes, I want to.
Then I'll ask you, sir, how do you plead to that state jail felony offense of possession of a controlled substance as alleged in the indictment? Guilty or not guilty?
Guilty.
And are you pleading guilty because you are guilty and for no other reason?
I want guilty.
I'll hear the evidence.
The state has 3 things to offer. The first piece of evidence is the incident or offense report from the day in question.
No objection.
Admitted.
The second is the initial case submittal and inventory report.
No objection.
Admitted.
And the third is the DPS lab report.
No objection. Your Honor.
Admitted. Anything else from the state?
No, Your Honor.
And on behalf of your client, Ms.
Judge
Thompson?
the board, Your Honor, vote to pass the court call. Conclude.
All right, then, Mr. Barker, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that state jail felony offense as alleged in the indictment. The court will follow the plea bargain, sentences you to 12 months in a state jail felony facility. You do have credit for 170 days as of today and orders you to pay your attorney's fees, court costs, and lab fee. And the court in punishing you has considered CR 21-0375-392. And so before you go, Mr. Barker, just a few more things to go over with you. Did you get an opportunity to review the judgment of conviction in your case?
Yes, sir, I did.
It's okay. Was your name, the charge, and the time credit correct?
Yes, sir.
Right. And finally, now that you've been convicted of this felony offense, you are now under Texas law ineligible to possess a firearm or ammunition. Those are legal terms. So if you have any questions about that, you need to consult with an attorney. You're now remanded back to the custody of the Henderson County Sheriff for transport to the appropriate authorities to serve out your sentence. Good luck to you, Mr. Barker.
Thank you, sir.
You need to see the bailiff before you go.
Thank you.
I don't believe that's all I have, Mr. Chief.
Yes, ma'am.
Thank you, sir.
Ms. Moore. Ms. Turner, come on up. Let's see the docket sheet. I know you already put it away. It's okay. All right, this is cause number CR 21-0223-392, the state of Texas versus Naomi Turner. Ms. Turner was not present when her name was called earlier and the court forfeited her bond. But let's go ahead and do discovery status. Where are we at?
Your Honor, we have received a discovery and an offer.
And what's the offer?
The offer is 2 years probation.
Ms. Turner, there's a couple things you don't want to be late for in life. Your wedding and felony court. Do you understand that?
Yes, sir. I apologize.
Well,
I do.
it's okay. You're here. And I'm kind of a first chance kind of guy. This morning, I was actually a fourth chance kind of guy. I don't know what happened there. But anyway,
I do apologize.
That's okay. I appreciate it. I'm going to order you to take a drug test. You're going to go take the drug test. When you get done, you're going to come back in the courtroom and we're going to go over the results together. The court deems discovery status is held. And we're going to talk again before you go, but your next court date will be July 6th at 1:30. What time is it? What time's your next court date?
1:30.
All right,
July 6th.
not 1:31,
No, 1:30.
1:30. There you go. All right, so take the drug test. When you get done, we'll go over the results together. Edwin Williams, pass your test, sir. You're free to go. Alan McAllister, pass your test, sir. You're free to go. Terrence George. Come on up, sir. Has he tested before?
No, sir. This is first quarter.
All right, it's back on the record in calls number CR 21-0267-392, State of Texas versus Terrence George. Mr. George, based upon the nature of your charges, I ordered you to take a drug test today. You took the test and apparently you tested positive for methamphetamine, amphetamine, and THC. Everybody gets one free shot in the court. Now you're on notice. I'm going to place conditions of bond on you because you already have them. All right, your conditions are no alcohol, no drugs not prescribed, and no illegal drugs, and that includes THC, whether it's marijuana, gummies, whatever. I know it's legal in a lot of states, but it's still against federal law, and it's still against Texas law.
Okay.
And so once you receive those written, signed by me conditions of bond, you're free to go, and we'll see you back on July 6th. But if you come back in the next time, when you come back in, I'm gonna drug test you. And if you test positive, I can't promise you'll go back out that door. You may go out that one, and that one leads to the jail. Do you understand?
Yes, sir.
All right. When you receive those conditions, after you talk with your attorney, you're free to go.
Well, I'll get him to sign it back there.
Yes, sir.
I'll sit back behind Mr. Hunt.
Mr. Hunt.
In front of me.
Mr. Lieberton, can you hear me?
Yes, sir, I can. Can you hear me? Yes, sir. I can hear you.
Oh, it sure is.
He's saying he can hear you.
Yeah, I got it. How about now?
Yes, sir.
There's a delay. There's a big time delay.
Liberty. Yes, sir.
Now it's echoing. Now it's repeating.
I know what it is.
You have the YouTube going?
I know what it is. I don't know how to get to YouTube though.
There it is. Over there it is. Oh, there you go. You can do that too.
Let's try this one more time, Mr. Lieberton. You got me?
Yes, sir.
Loud and clear.
There
I'm
we
going to
go.
call your case then. That's what was all the feedback. I didn't mute
Yeah.
the YouTube. That's what happens when we're out of court for 2 weeks. All right, this is cause number CR 21-0246-392, the state of Texas versus Jimmy Lieberton, set for discovery status.
Your Honor, I can tell the court I do have what I believe is all the evidence in this case, and I have received a very generous offer from the state. Mr. Lieberton is currently in a drug rehab in Dallas, and that's why he's appearing by Zoom today. As soon as he's released from that rehab, I've instructed him to contact me and to discuss that offer. So I believe we'll be able to take care of that case very quickly after he's released.
Do we know how long he's in there?
I can ask him if you would like.
Sure.
My discharge date is June 6th.
About another week.
Okay.
Okay.
What do we got before July? Let's just not wait for July. I'd rather get him when he gets right out. If we have something soon.
And I know I have a trial next week, Your Honor, starting the 8th. A CPS trial.
Are you already here on the 7th?
I can be here in the afternoon. Is it 1:30? Yeah, I can do that.
Mr. Lieberton, you get out when? Next week?
Well,
This coming Sunday.
yeah, the only problem with that though is I won't have a chance to speak with him and get all the paperwork done before that. So I'm not sure if
You
that,
don't want to do it sooner than?
well, is there anything next week?
Okay, let's just do July 6th then.
Okay.
All right, then, Mr. Lieberton, I am going to set your case. The court deems discovery status is held. Your next court date is July the 6th at 1:30. And as long as you've been discharged from that treatment facility, you need to be here in the courtroom at 1:30, okay, sir?
Yes, sir.
All right, so again, July 6th, 1:30, and we'll see you then. You're free to log off.
And may I say something?
Yeah,
to
go
him
ahead.
before
Hold
you-
on. Your attorney's got something to say to you.
Jimmy, I don't know if you can hear me. Can you hear me, Jimmy?
Yes, sir, I can.
As soon as you go home from this rehab, please get in touch with me, okay?
Yes, sir, I will.
Okay.
I'll text
thank
you before I get home.
All right, thank you. Thank you.
Thank
Judge.
you.
That's all.
You're free to log off, sir. Thank you.
Thank you.
Mr. Schmidt,
Yes, Judge. Mr. George, we discussed the positive sign the conditions of bond, and you told him he was free to go after we signed them, but there's the automatically check part about. reporting.
yeah, let me see that. I need to take that off. of there.
Okay, I didn't know if that was still.
So I'm taking these off.
Very good. I'll give them to everybody.
Sir.
And then back on Jack Ward, Your Honor.
He's got his sign. He's got his.
He does. We just have a question.
Mr. Ward, come on up. Back on the record in CR 21-0158, 59, and 160, all styled the state of Texas versus Jack Ward.
Judge, we've signed all the state filled out a number of conditions. We signed them all. There's no problem, but there is, it's just one part about reporting to bond supervision officer, and we just didn't know if the court required.
No, I'm not requiring that he report. Just-
Okay, so we'll just write that one out.
Yeah.
Then we're signed and ready to go.
Okay.
So he understands that all the other requirements.
All right, Mr. Ward, we'll see you in July.
Yes, sir. Thank you for your service.
Yes, sir. My pleasure.
Yeah, y'all figure out. Yeah.
That's all I have, maybe. Sure. Mr. Stevens.
I have a plea ready, but Mr. De Silva was negative. I don't know if they've given you that.
I don't have it yet. So I trust your copy. Mr. De Silva, you passed your test. You're free to go. See you in July.
And we're ready for.
July 6th. You got the reset notice, don't you? There you go.
We're ready for a plea on Justin Anding.
Justin Anding. All right, these are cause numbers CR 21-0256 and 0257-392, both styled the state of Texas versus Justin Anding, and both set for discovery status. However, a plea has been presented to the court. Is the state ready?
Yes, Your Honor.
And on behalf of Mr. Anding,
We're ready on.
sir, is your name Justin Bud Anding?
Yes.
And are you the same person that was originally indicted by a Henderson County grand jury in this 256 case of possession of a controlled substance?
Yes, sir.
If I can get you to raise your right hand, sir. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
You can lower your hand. Mr. Anding, can you read and write the English language?
Yes.
Are you a U.S. citizen?
Yes.
If it turns out you're not, and you enter into this plea bargain with the state, it can have certain negative immigration consequences. Do you understand that?
Yes, I do.
And Mr. Anding, have you ever been treated for any mental health or emotional issues?
No, sir.
Do you understand what's going on in here today?
Yes, I do.
And Mr. Stevens, do you believe your client is competent?
I do, Your Honor.
And the court finds he is competent. Mr. Anding, I know you've already been arraigned on this case. However, would you like the prosecutor to read the indictment out loud here in the courtroom?
No, sir.
But do you understand the charge?
Yes.
Well, as indicted, that charge is a state jail felony. A state jail felony carries a punishment range of not less than 180 days or more than 2 years in a state jail felony facility and a fine not to exceed $4,000. Do you understand that range of punishment?
Yes.
I got to write that down, didn't I?
10,000, Your Honor.
10,000. I don't know where my head is this morning. $10,000. Said that the last time. Not less than 180 days, no more than 2 years, and a fine not to exceed $10,000. Do you understand the range of punishment?
Yes.
And the plea bargain in the case?
The state is recommending 4 years of deferred adjudication and probation with credit for 3 days served, fine of $1,500, attorney's fees of $650, court costs of $365, and allowed fees of $80, along with standard conditions of probation.
All right, and considering CR 21-0257, it says 56 on the plea papers. Okay. So I just changed it. It had the right charge, just had the wrong cause number. All right, Mr. Anding, is that your understanding of the plea bargain?
Yes, sir.
And Mr. Stevens, is that your understanding?
Yes, sir.
Mr. Anding, a few minutes ago, you told me you could read and write the English language. I'm going to go over 2 documents with you. The first is the agreed plea recommendation. Did you read and go over both the front and the back and sign them with Mr. Stevens?
Yes.
Do you have any questions about it? The next document I'm referring you to is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document?
Yes, sir.
And did you sign that second page there?
Yes.
Do you have any questions about it?
No, sir.
Do you have any questions about any of the documents that you read and went over with Mr. Stevens?
No, sir.
Well, if you read and went over these with him, I know he explained to you that you have many constitutional rights, including the right to trial by jury.
Yes, sir.
Do you want a jury trial? You want to enter into this plea bargain?
Yes, sir.
And I'll ask you, sir, how do you plead to that state jail felony offense of possession of a controlled substance as alleged in the indictment? Guilty or not guilty?
Yes, sir.
And are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
I'll hear the evidence.
State has 3 pieces of evidence to admit. First is the incident or offense report to the date question.
Objection.
Admitted,
Second is the initial case submittal inventory report.
Objection.
admitted,
And finally is the DPS lab report.
Objection.
admitted. Anything else from state?
No, Your Honor, rest closed.
Rest closed as well.
All right, then, Mr. Anding, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty. However, the court will follow the plea bargain, defer making any finding, places you on community supervision for a period of 4 years. In sentencing you, the court is considering the cause number CR 21-0257-392. You do have 3 days credit to any sentence you may eventually have to serve and orders you to pay your fine, attorney's fees, court costs, lab fee, and abide by all the regular and special terms and conditions of community supervision. And Mr. Anding, have you ever been on probation before?
No, sir.
All right. Do you know what can happen to you if you violate this probation?
Yes, sir.
Well, if you violate, well, what can happen to you? That's right. And do you know how state jail time is served? How?
I'll look at it.
Generally day for day, you understand? Here's what can happen. If you violate even one term or condition of this community supervision, a motion would be filed, a warrant would be issued for your arrest, you'd be brought back before the court. And if at a hearing, the court found that you violated even one term or condition, the court could find you guilty, revoke your probation, and sentence you up to 2 years in state jail. Do you understand that?
Yes, sir. I did.
So would you agree with me? It's extremely important you abide by these.
Yes, sir.
I hope you do, sir. Good luck to you. Need to see probation before you go.
Our last case I've been talking to is David Allison. He's not present.
What are you trying to fix? Thank you, Kevin. Cause number CR 21-0248-392, the state of Texas versus David Allison. Is there a David Allison in the courtroom? I see no one. I hear no answer. Is there a David Allison appearing via Zoom? I see no one. The time, his name was called in the lobby. He's not there. The time is now 2:23. He was set for 1:30. The court will entertain a motion.
Thank you, Judge. State request bond forfeiture.
Granted a capious issue, and he'll be held with no bond. And if he shows up, I'm here most of the day.
Yes, sir. May I be excused?
Yes, sir.
Thank you, Judge.
Mr. Castleberry.
Yes, Your Honor, we have a lead on page 1.
Lynn Wheat. All right, this is cause number CR 21-0199-392, state of Texas versus Lynn Wheat, set for discovery status. However, a plea has been presented to the court. Is the state ready?
It's ready.
And on behalf of Mr. Wheat,
Defense is ready, Judge.
sir, is your name Lynn Albert Wheat?
Yes, sir.
And are you the same person that was originally indicted by Henderson County Grand Jury for this third-degree felony offense of driving while intoxicated?
Yes, sir.
I get you to raise your right hand, sir. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
And you can lower your hand. Mr. Wheat, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not, and you enter into this plea bargain with the state, it could have certain negative immigration consequences. Do you understand that?
Yes, sir.
And Mr. Wheat, have you ever been treated for any mental health or emotional issues?
No, sir.
Do you understand what's going on in here today?
Yes, sir.
Mr. Castleberry, do you believe your client is competent?
I do, Your Honor.
And the court finds he is competent. Mr. Wheat, I know we've already arraigned you on this case. However, would you like the prosecutor to read the indictment out loud here in the courtroom?
No, sir.
But do you understand the charge?
Yes, sir.
Well, as indicted, without any enhancement paragraphs, that charge is a third-degree felony. A third-degree felony carries a punishment range of not less than 2 years or more than 10 years in the Texas Department of Criminal Justice and a fine not to exceed $10,000. However, if you were to go to trial and a jury or a judge were to find the enhancement paragraph true and find you guilty, then the punishment range would be that of a second-degree felony. A second-degree felony carries a punishment range of not less than 2 years or more than 20 years in the Texas Department of Criminal Justice and a fine not to exceed $10,000. Do you understand both of those ranges of punishment
Yes, sir.
and the plea bargain?
Yes, sir.
The agreement is for 10 years TDC to be probated for 7 years with $1,000 fine. Attorney's fees, court costs. The defendant, as a condition of probation, is to take AA and or NA meetings, pay $50 to Crime Stoppers, urinalysis testing, obtain his GED within 24 months. His license is suspended for 365 days. He's to do 500 community service hours as a condition of his probation, attend victim impact, take the repeat DWI offenders program, complete a substance abuse evaluation and follow the recommended treatment. He's to install an ignition interlock, the full time of his probation. He's also to pay $60 in restitution to DPS Tyler, and as a condition of probation, he is going to do 10 days in the county jail.
Is that your understanding of the plea bargain, Mr. Wheat?
Yes, sir, it is.
And is that your understanding, Mr. Castleberry?
It is, Your Honor.
Well, Mr. Wheat, a few minutes ago, you told me you could read and write the English language. I'm going to go over 2 documents with you. The first is the agreed plea recommendation.
Yes, sir.
Did you read and go over both the front and back of that with Mr. Castleberry?
Yes, sir. I do.
And did you sign the front and the back?
Yes, sir.
You have any questions about it?
No, sir.
The next document I'm going to refer you to is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document?
Yes, sir.
And did you sign that second page?
Yes, sir.
Do you have any questions about it?
No, sir.
Do you have any questions about any of the documents that you read and went over with Mr. Castleberry?
No, sir.
Well, if you read and went over these with Mr. Castleberry, I know that he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
No, sir.
Do you want to enter into this plea bargain?
Yes, sir.
And I'll ask you, sir, how do you plead to that third-degree felony offense of driving while intoxicated as alleged in the indictment? Guilty
Your
or
Honor.
not guilty? Are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
I hear the evidence.
Thank you, Judge. The state offers an evidence states one, the offense report states two, is felony Morton compliance, and states three is the lab report.
No objection, Your Honor.
1 through 3 are admitted.
Thank you, Judge. And nothing further. That's
Nothing from the bench, Judge.
Rest and close.
Rest and close.
All right, then, Mr. Wheat, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that third-degree felony offense of driving while intoxicated. The court will follow the plea bargain, grants the state's motion to dismiss the enhancement paragraph or abandon the enhancement paragraph. Sentences you to 10 years in Texas Department of Criminal Justice. However, the court will probate that for 7 years. You do have 41 days credit as to any sentence you may eventually have to serve. And orders you to pay your fine, attorney's fees, court costs, and to abide by all the regular and special terms and conditions of community supervision. And Mr. Wheat, with all these DWIs you've got, I know you've been on probation before, haven't you?
Yes, sir.
And did you successfully complete any of them?
I did one.
Just one of them? Well, do you know what can happen if you don't successfully complete this one?
Yes, sir.
What can happen?
I wound up being.
All right, here's what can happen. If you violate even one term or condition of this community supervision, a motion could be filed, a warrant would be issued for your arrest, you'd be brought back before the court, and you wouldn't be entitled to bond. And at a hearing, if the court found that you violated even one term or condition, the court could revoke your probation and sentence you up in 10 years in prison. You understand that?
Yes, sir.
All right. And I tell people all the time, DWI is the stupidest reason in the world to go to prison. But I'll tell you a true story. As a prosecutor, the last 2 cases I tried with somebody kind of like you, just had a few more DWIs than you did. The jury gave them life in one and 99 years on the other for DWI. And those are Henderson County juries. You understand that?
Yes, sir.
So would you agree with me? It's extremely important that you abide by the terms and conditions of this community supervision. All right. Well, finally, sir, now that you've been convicted of this felony offense, you are now under Texas law ineligible to possess a firearm or ammunition. If you have any questions about that, consult with an attorney. Good luck to you, sir. You need to see probation before you leave.
Was there a motion to abandon or was it?
I granted it.
Okay.
What, did he plead? Was it
I
a
thought he-
second
I
degree?
thought he put true to it.
It said motion to abandon. Was there 2 answer paragraphs? No, you abandoned it. Oh, you didn't abandon it, did you? Then we need to go back on the
And he
record.
did- He was admonished on second.
I did admonish you. I'm sorry, I thought you abandoned it. So the court, there was no enhancement paragraph. I'm sorry, there was no motion to abandon the enhancement paragraph. The court finds you guilty, Mr. Wheat, of the underlying offense and has enough evidence to do so. The court also finds, well, I'm going to ask you, sir. I need to back up. Thank you for pointing that out. As to the enhancement paragraph, Mr. Wheat, is it true or not true that in February of 2015, in the 241st District Court of Smith County, that you were convicted of the felony offense of DWI?
Yes, sir.
And are you pleading true because it is true and for no other reason?
Yes, sir.
And the court finds it's true and had been previously found you guilty, finds you guilty of the second degree felony offense and follows the plea bargain. And so make sure we clear that up. Thank you.
I guess technically it's a third degree, but it's 2 to 20. I'm sure.
Right, I understand. All right, Mr. Wheat, you need to see probation before you leave. I don't know where I got $2,000, $4,000.
You'll get the probation.
I know.
And then the secretary said September 1st, the law changed or something? No.
It's got stuck in my head something.
That's from Mr. Lee, Judge. And then I have Sean Toller.
Mr. Toller, come on up. You know, give me just a minute, give my court reporter a little break, and let me look at the papers. I got it. I was giving Melanie a little break here because we've been rocking and rolling this morning and this afternoon. Y'all move all the cases, give me a month. They could give me 2 weeks without court and I get rusty. All right, this is cause number CR 21-0416-392. The state of Texas versus Sean Toller. And this is set today for a plea on an information. Is the state ready?
We are, Your Honor.
And on behalf of Mr. Toller,
And just ready, Judge.
all right, sir, is your name Sean Lee Toller? And are you the same person that's been charged by information with this third-degree felony offense of possession of a controlled substance? I can get you to raise your right hand the best you can, sir. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God. And you can lower your hand. Mr. Toller, can you read and write the English language? Are you a U.S. citizen? If it turns out you're not, and you enter into this plea bargain with the state, it could have certain negative immigration consequences. Do you understand that? Mr. Toller, have you ever been treated for any mental health or emotional issues? No, sir. Do you understand what's going on here today? Yes, sir. And Mr. Castleberry, do you believe your client is competent?
I do, Your Honor.
The court finds he is competent. Mr. Toller, you have not been indicted in this case that you are intending to plead guilty to today. Is that correct? Yes, sir. As a matter of fact, all that there is charging you is an information. And have you had an opportunity to review that information? Yes, Your Honor. And do you understand it? Yes, sir. You need the prosecutor to read it out loud here in the courtroom. No, sir. Well, that information charges you with a third-degree felony. A third-degree felony carries a punishment range of not less than 2 years or more than 10 years in the Texas Department of Criminal Justice and a fine not to exceed $10,000. Do you understand that range of punishment? Yes, Your Honor. However, it's my understanding that in exchange for your plea, the state is willing to recommend that the court punish you, convict and punish you under a state jail felony, a lesser included of that which is charged in the information. A state jail felony carries a punishment range of not less than 180 days or more than 2 years in a state jail felony facility and a fine not to exceed $10,000. Do you understand both of those ranges of punishment? Yes. In the plea bargain?
Your Honor, it's 2 years confinement in TDC. I'm sorry. In 416, Your Honor, it's 12 months confinement in the state jail felony facility credit for 198 days plus attorney's fees, court costs, and a lab restitution fee. We're also asking the court to consider an ag assault deadly weapon and a criminal mischief code unfiled from October and September respectively of 2020.
Are the victims aware and on board with that?
Figured you would ask Joe when I was checking. I'm through the ag assault, and I believe at the time they requested the charges not be filed. And that's related to criminal mischief as well.
Okay. Y'all, give me just a minute. Okay, she just did it. She was smoking in a corner. Doing her nails too. All right, Mr. Toller, is that your understanding of the plea bargain?
Yes, Your Honor.
And Mr. Castleberry, is that your understanding?
It is, Your Honor.
Mr. Toller, a few minutes ago, you told me you could read and write the English language. I've got a number of forms. I got 3 forms to actually go over with you. The first is the agreed plea recommendation. Did you read and go over both the front and the back of that with Mr. Castleberry?
Yes, sir.
And did you sign the front and the back?
Yes, sir.
Do you have any questions about it?
Yes, sir.
The next document I'm going to go over with you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document?
Yes, sir.
Did you sign it?
Yes, sir.
Any questions about it?
Yes, sir.
I don't know if y'all did the next document. Did y'all do a grand jury waiver? What's the plea on information?
It was provided to Mr. Castleberry.
Let's get a grand jury waiver. Well,
On the
y'all,
record,
I mean, it's a plea on information. You should know he's got to waive his right to a grand jury. I'm going to go over it with you orally, and then I'm going to have you step back and let Mr. Castleberry go over it with you. Mr. Toller, you understand in this case, you've only been charged by information. You understand that?
Yes, sir.
And in Texas, you cannot be held to answer for a felony offense unless and until a grand jury returns an indictment. Do you understand that?
Yes, sir.
You know what a grand jury is?
Yes, sir.
Can you tell me?
It's a group of people that the DA goes in front of and presents cases to see if they're going to move forward with the prosecution.
That's an outstanding answer. You're absolutely right. In a little more detail, it's 12 citizens that meet in secret. You don't have an opportunity to be there or even know it's going to happen, and neither does your attorney. And at that meeting, the state presents evidence, or another person could present evidence. And if 9 or more of those 12 believe there's probable cause that you committed this offense, then they return an indictment. If less than 9 believe there's probable cause, if you were being held on it, a letter would go over the jail saying, release Mr. Toller on this charge. You want to wait and see if a grand jury will indict you on this?
No, sir.
You want to waive your right to a grand jury and continue on with this plea bargain.
Yes, sir.
And if you were indicted, you'd have a right to trial by jury and many other constitutional rights. Do you want a jury trial or do you want this plea bargain?
I want to say what-
All right, then I'll ask you, sir, how do you plead to the lesser included offense, a state jail felony of that which is charged in the information, the possession of a controlled substance? Are you guilty or not guilty?
Yes, sir.
And are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
I'll hear the evidence.
Judge, that states 1, the offense report states 2, it might be more compliance, states 3 to 11 for
No objection, Judge.
Admitted.
state rests.
Interesting close, Judge.
All right, Mr. Toller, first of all, the court finds that you knowingly, intelligently, and voluntarily waived your right to a grand jury presentation of your case. The court then has enough evidence to find you guilty based upon your plea and the evidence, and does find you guilty of that lesser included offense, the state jail felony. The court will follow the plea bargain, considers these 2 unindicted cases in sentencing you, and sentences you to 12 months in a state jail felony facility with credit for 198 days and orders you to pay your attorney's fees and court costs. And before you go, Mr. Toller, did you get an opportunity to review the judgment of conviction in your case?
Yes, sir.
Was your name, the charge, and the time credit correct?
Yes, sir.
And finally, Mr. Toller, now that you have been finally convicted of this felony offense, you are now under Texas law ineligible to possess a firearm or ammunition. Those are legal terms. If you have any questions, consult with an attorney. You're now remanded back to the custody of the sheriff for transport to a state jail facility to serve out your sentence. Good luck to you, sir. Need to see Mr. Halbert, the bailiff, before you sit down.
I'll get this for you, Judge.
Yes, sir. Mr. Mills.
Page 6, Jesse Webb.
Jesse Webb. These are cause numbers CR 20-0709 -392 and CR 21-0110-392, both styled the state of Texas versus Jesse Webb. And let's see, one is set for pretrial and the newer one is set for discovery status. Any pretrial from the state? None?
I mean, we have an offer out. but that's close.
Okay. Any on behalf of the defense?
No, Your Honor, they,
I'm sorry.
go ahead.
Can you sign the standard discovery order?
I sure will. Any objections?
No,
Tried to cue you.
Sorry.
no objection.
All right, granted. And any on behalf of Mr. Webb?
No, Your Honor.
All right, well, then the court deems pretrial is held on that case. And moving on to the newer case, where are we at on that one with discovery?
Judge, they've sent me the discovery and I also have a plea offer, which I anticipate we'll probably be accepting.
What's the offer?
We have two offers. One
fine.
is 2-year deferred and the other is 85 days county jail. Either one would take into consideration the overtime.
All right, then, Mr. Webb, in that case, the court deems discovery status is held. I'm setting both of these cases. I'm just going to reset them both for pretrial so they run at the same time for July 8th at 1:30. However, before you go, I'm ordering you to take a drug test. You'll go with probation, take the test. You know the drill. When you get done, come back in the courtroom and we'll all go over the results together. That's right. You got Cooper and Dorsey.
Yes, sir. Dorsey's here.
Okay, Dorsey. Charles Dorsey. Can I see the docket sheet? All right. These are cause numbers CR 21-0249 and 0250-392, both styled the state of Texas versus Charles Dorsey, and both set for discovery status.
Judge, I believe I've received all the discovery. Plea offer.
Anything outstanding, labs,
I don't believe so, Judge.
and an offer?
Yes, Your Honor, the current offer is 20 years on the Mandel. And given consideration.
Okay. All right, then, Mr. Dorsey, the court deems discovery status as held. Your next court date is July 6th at 1:30 for pretrial. And he passed his last drug test, did he not? Well, he had opiates, but did he have a prescription? Supposed to bring it today. All right, I'm gonna order him to take a drug test. Mr. Dorsey, you'll go with probation, take the test. When you get done, come back in the courtroom. We'll go over the results together. And your next court date's July 6th at 1:30, but don't leave till we talk about your drug test.
Here's the order, kind of.
All right. Thank you. Dorsey. Webb.
Cortez Cooper for arraignment.
Cortez Cooper. This is cause number CR 21-0198-392. State of Texas versus Cortez Cooper, set for arraignment. Mr. Mills.
Judge, Mr. Cooper's name is spelled correctly in the indictment. He understands what he's been charged with. We'll waive the formal reading of the indictment. Enter plea of not guilty to the charge and not true to the enhanced paragraph.
All right, Mr. Cooper, the court notes your plea of not guilty and not true for purposes of arraignment. Your two next court dates are August the 4th at 9 a.m. for for discovery status. And then again on September the 1st at 9 a.m. for pretrial. So as soon as you receive your reset notice, sir, you're free to have a seat. If you get out of jail between now and then, I need to see you in August. Even if you break out of jail, I need you to come back in here in August. All righty.
That's all I have.
We'll see you. Mr. Scott.
Lindsay Martinez, Your Honor, for plea.
So good.
Questions. Finish what he has to say and then speak up. She has to write down what we're saying.
All right, this is cause number CR 21-0281-392, the state of Texas versus Lindsay Ray Martinez. And this was set for discovery status today. However, a plea has been presented to the court. Is the state ready?
Yes, Your Honor.
And on behalf of Ms. Martinez,
Yes, sir.
ma'am, is your name Lindsay Ray Martinez? And you got to speak a little louder than that because Melanie and I are both hard to hear. All right, and are you the same person that was originally indicted by a Henderson County grand jury for the state jail felony offense of possession of a controlled substance? I need you to raise your right hand, please. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God. You can lower your hand. Ms. Martinez, can you read and write the English language? Are you a U.S. citizen? If it turns out you're not, and you enter into this plea bargain, it can have certain negative immigration consequences. Do you understand that?
Yes, sir.
And Ms. Martinez, have you ever been treated for any mental health or emotional issues?
Yes, sir.
Do you understand what's going on in here today?
Yes, sir.
Mr. Scott, you believe your client is competent?
I do, Your Honor.
Court finds she is competent. Ms. Martinez, I know that we've already arraigned you on this case. However, would you like the prosecutor to read the indictment out loud here in our court? I don't know.
Yes,
But do you understand the charge?
yes.
Well, as indicted, that charge is a state jail felony. A state jail felony carries a punishment range of not less than 180 days nor more than 2 years in a state jail felony facility and a fine not to exceed $10,000. Do you understand the range of punishment?
Yes, sir.
In the plea bargain, state?
Your Honor, the state is requesting that the defendant do 2 years probation as a deferred adjudication guilt under 1244B, along with $1,000 fine, $500 attorney fees, $365 court costs, $180 lab fee, standard terms and conditions of probation, and $180 restitution.
Right, and just a minute ago, Ms. Martinez, I told you about the state jail range. But also, as you just heard, the state's recommending this be punished under 1244B of our penal code, which allows a court to take a state jail felony and convict you as a Class A misdemeanor and punish you as a Class A misdemeanor. The punishment range for a Class A misdemeanor is up to 1 year in the county jail and a fine up to $4,000. Do you understand that range of punishment?
Yes, sir.
And is that your understanding of the plea bargain?
Yes, sir.
Is that your understanding, Mr. Scott?
Yes, sir.
Well, Ms. Martinez, a few minutes ago, you told me you could read and write the English language. I'm going to go over a couple documents with you. The first is the agreed plea recommendation.
Yes, sir.
Did you read and go over the front and back and sign them?
Yes, sir.
Any questions about it? The next document is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document?
Yes, sir.
Did you sign that second page?
Yes, sir.
Do you have any questions about it?
Yes, sir.
Do you have any questions about any of the documents you read and went over with Mr. Scott? I heard him tell you, wait for me to answer to finish. She can't take us both talking at once, okay? You nervous?
No, I'm not. I stand at home.
Oh, okay. Well, then we'll get you out of here. All right. Well, Ms. Martinez, if you read and went over these with Mr. Scott, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
Yes,
Do you want to enter into this plea bargain?
yes, sir.
And I'll ask you, ma'am, how do you plead to that state jail felony offense as alleged in the indictment, punished and convicted under 1244B of our penal code? Are you guilty or not guilty?
Good.
And are you pleading guilty because you are guilty and for no other reason?
Yes,
I'll hear the evidence.
Yes, Your Honor, we have 3 things to enter into evidence. The first is an instant or offense report from the day in question.
No objection, Your Honor.
Admitted.
The second is initial case submittal inventory report.
No objection, Your Honor.
Admitted.
And the third is the DPS lab report.
No objection.
State rests in peace.
Admitted.
Defendant rest and close, Your Honor.
All right, and Ms. Martinez, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty. However, the court will follow the plea bargain, places you on deferred adjudication as a Class A misdemeanor under 1244B of our penal code for 2 years. You do have a day credit as to any sentence you may eventually have to serve. In order you to pay your fine, attorney's fees, court costs, and lab fee, and to abide by all the regular and special terms and conditions of community supervision, including paying that $180 restitution to DPS. Ms. Martinez, have you ever been on probation before?
yes, sir.
And did you successfully complete it?
Yes,
You know what can happen to you if you don't successfully complete this community supervision?
yes.
What can happen?
Everybody got,
We're up to how long?
2 years.
1 year because it's under Class A. Here's what can happen if you violate even one term or condition of this community supervision. A motion would be filed, a warrant would be issued for your arrest. You'd be brought back before the court, and if at a hearing, the court found that you violated even one term or condition, the court could find you guilty, revoke your probation, and sentence you up to a year in county jail. You understand that? All right, well, good luck to you, ma'am. I hope I don't see you back in here on this. You need to see probation before you leave.
See, and they'll probably tell you to go over to their office. Call me, then question. Yeah, can I give you this in the PTI from earlier?
Yes, sir.
Thank you, Jeff.
Mr. Head. Mr. Darby, come on up. This is, or we are back on the record. And could we have Colin in here? Yeah, I'll call it and then we'll get it. CR 21-0176-392, the state of Texas versus Cross Darby. And I'd ordered Mr. Darby to take a drug test state.
Your Honor, I believe that Mr. Darby had a bottle of fake urine. You can call a witness if you'd like to.
Fake urine or someone else's urine?
I don't know if it's fake urine or someone else's urine, not his urine.
Okay, well, Mr. Head, do you have anything to add at this point?
Your Honor, no, if the state has a witness,
Sure.
obviously we'd ask to be allowed to cross-examine them.
Absolutely.
but invoke Mr. Darby's Fifth Amendment right not to testify.
I believe it's going to be Mr. Jeffers.
Okay. I still got Mr. Green on Zoom. I hadn't forgot about him. I just hadn't had a break to get to him. Yeah, thank you.
Steve was the one that.
Yeah, that's what they just said. Mr. Jeffers is coming. Can I see the docket sheet, Sam? Well, I apologize. I thought we were ready. I see him coming. Well, I thought I did. Do we have any other drug tests back? Okay. We're still out? All right, I think I've already called it. So does the state have a witness?
We do call Steve Jeffers.
And does anyone mind if I waive the oath? He's an officer of the court.
There you are.
No objection, Your Honor.
All right, state.
Mr. Jeffers, did you recently observe an attempted drug test on Cross Darby?
Yes.
And why were you observing the drug test?
I didn't work for the court.
Could you tell the court what happened?
I originally took him in the bathroom, asked him for the sample, he said he couldn't go. He left to go get a drink of water, came back, and then he was trying to give me the sample, and he started spilling all over the ground. I found him in possession of a bottle.
Did he make a statement to you about the bottle?
Yes, he said somebody out here had told him that They had left a bottle of urine in the bathroom over here that he could get and substitute for his urine.
Mr. Head,
Did he, is it my understanding that it's your testimony, did he actually try to pass it off as a specimen, or he spilt it and made some sort of admission to it?
He was taking the cap off, trying to get it in my cup where I could read it. Started spilling it. That's why I told him to stop, put the cap on, and I'd asked him a couple of times to retrieve it from his pants, and over his pants, so he had it right here.
But I just wanted to make sure I understood that he was in possession of it, but he did not try to actually pass it off to you as his urine sample.
He was trying to, if he could have gotten that sample into my urine cup, he would have been trying to pass it. Yes, that was his intent.
I understand that was what you felt like his intent was. I just wanted to clarify that he didn't actually say, here's my urine in your specimen bottle.
He was unable to get rid of the sample before I put it away.
I'll pass it.
anything else? Any other witnesses?
No, Your Honor, best.
Mr. Head?
Your Honor, we don't have any additional witnesses.
Okay. All right. Any, y'all want to close?
Your Honor, I ask that you find his bonds is insufficient, raise his bonds.
Mr. Head?
Your Honor, we don't have anything additional. There was an offer, we would, it was a probation offer. It's my understanding that offer may be withdrawn. But we would ask that we'd be able to reset this to a time when we can reevaluate the bond or the offer fairly soon if he's taken into custody.
Yes, sir. All right, well then, let's see. First of all, then the court finds Mr. Darby's bonds on each case insufficient. I need to see either the files or I need the bonds, so I can see the bonds on the indictments.
Had the indictment.
Sure.
On 0174, the indictment lists a bond of $30,000.
0174, it's 30,000.
Yes, Your Honor.
All right, and the court finds the bonds insufficient on CR 21-0174-392, and that bond is now a $60,000 surety bond.
Your Honor, on 0175, the bond is $30,000.
All right, then in CR 21-0175-392, the court finds that bond insufficient and raises the bond to $60,000 surety bond. In 0176, the court finds that bond insufficient. All right. Oh, we need to back up. He's telling me that I've already lowered these bonds on a motion to reduce bond. That they were 10,000, but the court's still finding them insufficient, raises 0176, even with the additional knowledge to $60,000 surety bond. And then what is it on 0440?
On the indictment, it lists $8,500.
All right, then in CR 21-0440, which is the controlled substance case, the court finds his bond insufficient, sets bond at $150,000 surety bond. And y'all want a quicker reset date?
Yes, sir, Your Honor. If we could get something sooner than the August date, I think, which is currently our setting.
Yes, sir. July 6th, that work for you? What time, 9 or 1:30? July 6th, 1:30. So, Mr. Darby, you're going into custody. Go ahead and have a seat in the jury box, and we'll give you those reset notices. Stay in touch with Mr. Head.
Your Honor, that's all I have, ma'am. Excuse.
Yes, sir. All right, Mr. Green, we just got a break now. You there with us?
I'm here, Judge.
All righty, who you got?
Start with Amanda Baldwin. She is on Zoom as well because of COVID concerns.
Amanda Baldwin. Is that Miss Ball? Was that when I smoked her earlier?
Well, Judge, I wasn't.
Oh, yeah, I'm sorry, I didn't know.
Your Honor, on 0173, the court did not set a bond on that. There was an additional fee that's on the bond.
What's the bond on that one? At $60,000 surety bond, I find it insufficient, set it at 60,000 surety bond. Ma'am, can I see, are you on video?
Yes, I am. I don't know how to make my picture come up. Okay, wait, push start video.
Yep.
I pushed it. It says the host has to do it.
I think, Judge, maybe you turned her off.
No, I didn't turn her off. Well, did you do something?
Video, there's a line for it, and I pushed it. I pushed start video.
Okay, can you hear me okay? Ms. Baldwin, can you hear me?
Okay, I'm back.
Okay, you can hear me?
I can hear you, but my picture's still not coming up.
That's okay. All right, cause number CR 21-0231-392, the state of Texas versus Amanda Baldwin, set for discovery status. Mr. Green.
Judge, as far as I can tell, we have all discovery from the state related to Ms. Baldwin's case.
Everything's been provided.
Is there an offer?
There are two offers. One is a 10 TDC probated for 7, and the other offer is 5 years TDC.
Can I see the docket sheet? And so Ms. Baldwin is not appearing. Why?
Because of COVID concerns, Judge provided a letter from the hospital to Mr. Inslee this morning, and she was asked to, or told by the hospital to quarantine through Thursday.
Till the 3rd?
Yes,
What day
sir.
is the 4th? That's a Friday, right? All right, well, then the court deems discovery status is held. Ms. Baldwin, your next court date is July 6th at 1:30. Can you hear that?
Yes, sir.
All right, however, on June the 4th, you're going to report to probation. What time? At 9 a.m. Henderson County Community Supervision Department at 9 a.m. to take a drug test. Do you understand?
Yes, sir.
All right, so
If you
what date?
want, I could go up to the hospital or something and pay to have one done if you'd like.
No, that's okay. So Ms. Ball, I appreciate the offer, but I'm going to have you report June 4th, 9 a.m. Community Supervision Department right here beside my courtroom. And then again for pretrial on July 6th at 1:30, okay?
Okay. I couldn't hear when they were talking about, is there an offer there? Is there? I
The
couldn't hear
offer's either
whenever y'all
5
were
years
saying
to
something
do
about an offer.
or probation. So call Mr. Green.
Okay, yes, sir.
All right, we'll see you on June 4th. Thank you, ma'am.
Okay, thank you.
You can log off now.
Okay, thanks. I'm trying to figure it out. I'm trying to figure it out. How to log out.
All right, and then you got a writ on Mr. Bowman?
Judge, if I could do these discovery status hearings
Okay.
real quick first.
Sure.
Next one is Nathan Lozano.
Come on up, Mr. Lozano. And if you'll camera right there is where Mr. Green can see you. So come on up right here. And he can see you right there. All right, this is cause number, or these are cause numbers CR 21-0215 and 0216-392, both styled the state of Texas versus Nathan Lozano, and both set for discovery status. Where are we at?
Judge, best I can tell, we've received all the discovery in Mr. Lozano's cases, I should say.
In an offer?
That's correct. The offer was 7 years deferred probation on the possession of TSC.
All right, then, Mr. Lozano, the court deems discovery status is held. Your next court date is July the 6th at 1:30. And based upon the nature of your charge and your previous drug test, you know the drill. I'm ordering you to take a drug test today. You'll go take the test. When you get done, come back to the courtroom. We'll go over the results together.
Yes, sir.
Thank you, sir. And let's see, Jacob White.
Jacob White, Judge, I don't know that he's made it. I received over lunchtime a telephone message from his stepfather or a person who identified themselves as his stepfather, that Mr. White was very ill today and was at the emergency room in Tyler. I have not had an opportunity to reach out to that person to try to get any verification of that.
Can I see the docket sheet? Trying to interrupt her. You know, I think if they did a scientific study on people that test positive previously, it seems like they're more susceptible to sickness and COVID. It's just an observation. But we'll go ahead.
I'm ready for car trouble again, Judge.
All right, well, then I'll call his name. It's case of CR 21-0244 and 0245-392. Both style, the state of Texas versus Jacob White. Is there a Mr. White in the courtroom? I see no one. I hear no answer. Is there a Mr. White in the lobby? All right, not in the lobby. Is there Mr. White appearing via Zoom? I see no one. The time is now 3:08. The docket was for 1:30. Court will entertain a motion.
We would request bond forfeiture.
Granted, case of issue, he'll be held with no bond. And Mr. Green, if you do get a medical
Yes,
letter,
sir.
I'll certainly reconsider.
Yes, sir.
But I would be willing to bet that people that are that do have a substance abuse problem with meth are probably get sicker if they do get COVID. I would just guess.
I would suspect their immune system is not as strong as others as well.
Yes, sir. And then you got, Mr. Green, you got these two writs. Which one you want to do first?
Judge, I did want to make sure, I got appointed on Friday to Brandon McClure, and I received a text from Mr. Head that Mr. Weiner had been retained and that he was going to, Mr. Head was going to stand in for him and do the arraignment this afternoon, but it may have happened when we weren't getting any volume on our end.
My battery was dead on my microphone, but yeah, that did happen. And so,
Okay. Just want to
we
make
took care
sure.
of him. Yes, sir.
So I'm ready for Christina Williams Blackburn, Judge.
Blackburn, come on up. This is CB 21-0241-173 ex parte Christina Ray Williams Blackburn, set today on a writ seeking bond reduction. Is the applicant ready?
Yes, we're ready, Judge. I'm sorry.
And on behalf of the state,
We're ready, Your Honor.
and are we going to hear testimony from your client, Mr. Green, for the limited purposes of bail?
We are, Your Honor.
All right, Ms. Williams Blackburn, if you could raise your right hand the best you can. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You can lower your hand. Mr. Green, step up a little bit more. Here you go.
Thank you, Judge.
If you look right into there, he can see you.
Ms. Williams, you're in fact Christina Williams Blackburn, is that correct?
Yes, sir.
And you're currently confined in the Henderson County Jail, correct?
Yes.
And you're being held on the charge of possession of controlled substance under 1 gram in a drug-free zone, correct?
Yes, sir.
And that bond is currently set at $15,000.
Yes, sir.
And if I hadn't already said it, you've been in jail since April the 30th of 2021.
Yes, that is correct.
And is it a fair statement that you have not been able to make that bond?
That is correct.
And it's your opinion that if it stays at $15,000, you will not be able to make that bond?
That is correct, sir.
You're a resident of Arlington, Texas, correct?
Yes, sir.
And if you get out of jail, you'll be returning to your residence in Arlington, correct?
Yes, sir. That's what I plan on doing.
And can you tell the judge who you were living with in Arlington before you went to jail?
So I was homeless, but I'm on and off with my mother.
And so is it a fair statement that if you are released from jail, that you will not be homeless and you will have a place to stay with your mother?
That should be okay. I'm not exactly 100% sure, but if not, there is the Arlington Life Shelter that I would be able to stay at.
And if you're in Arlington, will you have any difficulty returning to court in Henderson County when you're told that you have to be in court in Henderson County?
No, sir. That
And
should-
how would you, what kind of transportation will you have, or who will help you with transportation?
My mother would help me, or my aunt, and there is a Greyhound bus station.
What's your mother's name
Gina Williams,
and your aunt's name?
Kimberly Bailey.
Ms. Williams, to be candid with the court, you're currently on a bond out in Eastland County, is that right?
Yes, sir, that is correct.
And that's for 2 different charges.
Yes, sir.
And that was for possession of a controlled substance, 1 to 4 grams, and for tampering with evidence.
Yes, sir.
And that you made bonds that totaled $30,000, or someone helped you make that.
$3,500. Yes, sir. Someone paid for it for me.
Okay, so they were set at 30,000. You paid a bondsman, or that person paid a bondsman for you in the amount of $3,500.
Yes, sir.
Is that person capable of helping you make the $15,000 bond here in Henderson County?
No, sir.
And those were charges that happened, I think you told me 6 to 7 months ago.
Yes, sir. As far as I remember, yes.
And as of today, you have not been indicted.
Correct.
You also told me that there was a time when you were on 3-year deferred probation. Is that right?
Yes, sir. That's correct.
And that was for possession of controlled substance under 1 gram.
Yes, sir.
And that you eventually were revoked on that probation and served or got credit for 10 months.
Yes, sir. That is correct.
And that is the extent of your criminal history.
As far as felonies go, yes, sir.
All right. You think that, and we talked about it, you think that you can potentially make a bond around $5,000 or have somebody help you make that bond?
I can try.
Okay,
Yes, sir.
all right. Judge, I pass witness.
Ross?
We have no further questions, Your Honor.
And do you have a copy of the probable cause affidavit?
We do.
And Mr. Green, have you been provided a copy of that?
Judge, I didn't get one from the state, but I did obtain it from the jail a few weeks ago, and I have reviewed it. And just to point out for the court, since the courts, we can get down to the chase, she was just within, was not on school property, was just within some distance within 1,000 feet of school property. Drive either highway or on either highway through Crossroads, you go right by the school.
Hard time reading this writing. For some reason.
It's very difficult, and I went over it with Miss Williams this morning. What it is the first letter of every word is capitalized, and then each letter of each word after the capitalization is small caps.
Small caps, it's legal printing. So it looks like there was a PI, public intoxication, search incident to arrest, they found possession of control, so allegedly.
Yes, sir.
Anything else? Mr. Green, anything else?
Judge, we just asked the court to reduce Miss Williams' bond to $5,000. We think that while we understand that our law does provide for enhanced penalties for drug-free zone violations, I think in many times there's no correlation other than just being somewhere. And I think that's, in this case, it would have been a state jail possession case. And I think $5,000 is in line for that type of case.
I think at one time when I was DA, we kind of looked at the city of Athens, and just about everywhere in the city, you could make a drug-free zone because there's a preschool or a school or a church
Yes.
that has preschool or other establishments. But I mean, there's a reason.
Well, I certainly think there's a reason, and I think that it was designed to punish the people who are seducing our children with drugs and or delivering in an area near the schools.
Understand.
I don't think that's what we have here.
Well, but I do have a concern that she's on bond out of Eastland County on 2 cases, that she's also been previously convicted of an offense and I guess got 10 months. I'm also concerned that she doesn't have steady household. So what I'm going to do is I'm going to grant the motion to reduce bond. I'm going to reduce it to $10,000, but on the condition that she live with her mother. And
Okay.
if mom doesn't take her in, then she doesn't get out on bond. And also, how old is she, Mr. Green?
How old are you, Christina?
I'm 30 years old.
Okay, you ever seen Faces of Meth?
I have.
Yeah, you need to look in the mirror when you get to the jail. And then if you are doing meth, I'm not saying you are, you're presumed innocent, you're gonna look drastically different in 5 years. Right. So if you need help, get it. There's lots of help out there. It looks like you do.
May I say one thing?
Well, you can, but I don't know if your attorney wants you to.
Sorry.
I don't think I think we're good, Christina, and we can visit.
Okay, yes, sir.
Yes.
Sorry.
You can have a seat, man.
Okay, thank you.
Judge, I'll get you an order.
Yes, sir. Thank you. You all right? You good? All right, and let's see, we've got
Quaylen Bowman, Judge.
Mr. Bowman, come on up, sir. Mr. Lozano, pass your test before you go, sir. We'll see you in July. Ms. Turner. Is that her first one or not? It's her first one. Okay, Mr. Green, if you don't mind, if I can handle, get rid of some of these people. Let's go back on, you can stay right there, Mr. Bowman. Ms. Turner, come up real quick. It's cause number CR 21-0223-392, the state of Texas versus Naomi Turner. Ms. Turner was sent to take a drug test. It was her first drug test for the court. Apparently, she's tested positive for meth, amphetamine, and opiates, and she admitted to swallowing a pain pill and an ADHD pill. And so I don't see anything about a prescription. Ms. Turner, it's your first time. The court's going to place you on conditions of bond, no alcohol, no drugs not prescribed, no illegal drugs, and that includes marijuana or THC. Do you understand? And so I'm going to do, once you stay in the courtroom until you receive a signed copy of the bond conditions from me. We'll see you in July. If you come in and test positive in July, I can't promise you'll go out that door. You may sit in the jury box until they're ready to take you to jail. Do you understand that? Okay, thank you. All right, thanks, Mr. Green. I'm trying to clear the courtroom with some of the folks.
Yes.
All right, and so this is CV 21-0240-173, and that is ex parte Jaqueline Javon Bowman, set today for a writ seeking bond reduction. Is the applicant ready?
We're ready, Judge.
And on behalf of the state
Ready, ready.
and Mr. Green, are we going to hear testimony from your client for the limited purpose of bail?
Yes, sir.
All right, Mr. Bowman, I'm going to swear you in, but I'm not going to let anybody ask any questions about any alleged offense, just about bail, okay? You can raise your right hand the best you can. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
You can lower your hand. Mr. Green.
Mr. Bowman, you are Quaylen Bowman, is that correct?
You can see.
Yes, sir.
Camera's right
And
there.
your fair statement that you are currently confined in the Henderson County Jail,
Yes, sir.
and you've been in the Henderson County Jail since April the 30th of 2021, correct?
Yes, sir.
And you're currently being held on 2 felony charges, correct?
Yes, sir.
And one is a deadly conduct, and your bond is set at $15,000, correct?
Yes, sir.
And the other one is manufactured delivery of controlled substance, penalty group 1, 4 to 200 grams, correct?
Yes, sir.
and its bond is currently set at $100,000. Is that correct?
Yes, sir.
And you've previously made bond on the deadly conduct charge late last year, correct?
Yes,
Or
sir.
maybe in January. It was late last year, in December, right?
Yes, sir, December 15th.
Sometime in there.
Yes, sir.
Okay. And you understand that your bondsman has done a release of surety on that case, and because you were arrested on this other one.
Yes, sir.
Okay. And and you've been in contact with that bondsman, and you feel like there's a good chance that they will go back on that bond, correct?
Yes, sir.
And so though we've asked the judge to consider a bail reduction in that deadly conduct case, your concern is this $100,000 bond. Is that right?
Yes, sir.
You live over in Tyler, right?
Yes, sir, my mom.
And your mom's name is Shanika Miller.
Yes, sir.
And if you're released from jail, that's where you'll be living, correct?
Yes, sir.
And just for the judge to know, you're 21 years old.
Yes, sir.
And when you were out of jail on that deadly conduct charge, you were reporting you had conditions of bond that Judge Calhoun had set, right?
Yes, sir.
And you were reporting monthly to Brenda Skinner.
Yes, sir.
And during that time, you reported when you were supposed to and paid fees that you were supposed to,
Yes, sir.
and no positive urinalysis test.
Oh, yes, sir.
Okay. We've talked, and you feel like that, well, let me, before I go there, and other than these two arrests that you're before Judge McKee today on, you've never been arrested for anything else?
No, sir, just these two charges.
Okay. And you and I talked about that $100,000 bond, and you feel like that you would be able to raise the funds to make a $25,000 bond in that case.
Yes, sir.
And that's what you're asking Judge McKee to do, is reduce this $100,000 bond to $25,000.
Yes, sir.
I'll pass the witness, Your Honor.
Mr. Bowman, I may have missed it. Are you working?
No, ma'am.
You don't have a job?
Oh, not right. I was, no, ma'am, I don't.
Are you a member of the Athens Sniper Gangsters for Life?
No, ma'am.
I'll pass the witness, Your Honor.
Mr. Green?
Did state rest?
No, we did not.
I was having a hard time hearing him.
She asked him one question and then passed.
Okay. I have no further questions, Judge.
All right. Any other witnesses? Mr.
No,
Green?
Your Honor, we rest and close.
And Ms. Palmer?
We call Tolan Larry.
Anyone mind if I waive the oath? He's an officer of the court.
No, Your Honor.
No, Judge.
I want to make sure that Mr. Green can hear me.
He
Do I
should
need
be
to
able to.
move closer?
If Mr. Larry steps closer, he'll be on camera. A little closer, told right there. You're
Mr.
good to
Larry,
go.
would you state your name, please?
My name is Tolan Waiver.
And are you familiar with the defendant?
Yes,
He's on conditions of bond with your department, is that correct?
that is correct.
Are you aware of who the defendant was arrested with?
Yes,
Right, and is that Sabian and Justin Young?
that is correct.
Are both of them on felony probation?
Yes, they are.
Are you aware of the criminal street gang Athens Sniper Gangsters for Life?
Yes,
And have you watched videos of the Athens Sniper Gangsters with guns and drugs and things of that nature?
yes,
Have you seen the defendant in some or more than some of those videos that have been posted?
yes, I have.
And you were able to recognize him with those people that are on felony probation, is that correct?
That is correct.
I'll pass it.
Mr. Green?
Mr. Larry, and you'd agree, simply because he was in a video with them doesn't mean he's a member of any of gangs with them, correct?
I can agree to that. I can agree to that. I
I
can
have no
agree
further
to that.
questions, Judge.
No more questions?
None, Judge.
We rest.
Redirect, press. And is your probable cause affidavit?
I have one, Your Honor.
And Mr. Green, have you been provided a copy of the probable cause affidavit?
I have, Your Honor.
Okay. If y'all give me just one moment. There's a search warrant I signed.
Correct, Your Honor.
So do you have the warrant or the probable cause affidavit?
I've got the probable cause affidavit.
Okay.
And do you have the warrant, the search warrant I signed?
I believe I do, Your Honor.
I want to see that one again because I want to say.
Judge, I received it this morning through the help of Mr. Inslee, and my recollection, though I haven't read it in quite deep.
I don't think he was named in it.
He was not named in it.
No, Your Honor.
But let me just ask you this, was the street gang named in it? Or the alleged street gang, I guess I should say.
I think it was named perhaps in Miss, well,
I could have just a moment, Your Honor.
Sure.
what her last name, Miss Hampton's affidavit.
And just to refresh my memory, many of those street gang members or alleged street gang members are in jail now on some of them on over $1 million bonds. Is that correct? Is there some with $1 million bonds?
Judge, I don't recall $1 million bond. I believe several of them are $150,000.
Okay,
So there were two affidavits, Your Honor. The first was a search warrant affidavit that did not name this particular defendant.
was there a secondary one for the car?
And then there was a
Yes.
secondary warrant that was for the defendant, Sabian Young. That does mention the Athens Street Gang.
Okay. All right, anything else?
No, Your Honor.
All right, well then, the court respectfully denies the request to reduce bond will remain where it's at.
Thank you, Your Honor. That's all my business, ma'am.
Yes, sir. Thank you for holding on for us.
I'll see you in person in the morning. I was a little under the weather today and didn't need to wander too far from the house.
I'll be here.
All right, thank you.
Yes, sir. You want to keep driving through or you want to take a break? How many more have we got?
I just have one.
Okay, come on up. How you doing?
Good. I'm multitasking. I had a CPS thing in the other room over there.
Okay. I saw you here earlier. All right, Mr. Eaton, this is cause number CR 21-0172-392, the state of Texas versus Douglas Eaton, and that is set for discovery status.
Status on the discovery, Your Honor. We picked up what was outstanding, which was a disc that contained some body cam and some 911 calls. At this point, I think what we have is all of the discovery, and I think we have an offer from the state. There is, Your Honor. It's 3 years TDC.
Okay. All right, well then, the court will deem discovery status as held. Mr. Eaton, your next court date is July the 6th at 1:30 for pretrial. So as soon as you receive your reset notice, you're free to go. Stay in touch with your attorney and your bondsman, sir.
Thank you, Judge.
Sir, see you.
You get your reset.
Oh, no, he's got to get his reset notice. Mr. Dorsey, I'm not Mr. Dorsey, Mr. Eaton. Mr. Dorsey, you come on up anyway. You got to get your reset notice. Who's his attorney? And he's already gone. All right, it's cause number CR 21-0249-392, the state of Texas versus Charles Dorsey. And this is set, well, I'd ordered him to take a drug test, and apparently Mr. Dorsey had tested positive for opiates. And apparently, allegedly admitted to hydrocodone. It has no valid prescription. He tested positive for opiates last time, did he not?
Yes, sir.
Where's your attorney at, Mr. Dorsey? He left? Well, I don't want you to say anything without him here. I'm gonna deal with you in July. But I already have conditions of bond on him, right? Okay, Mr. Dorsey, I'm gonna wait until your attorney's here. I will tell you, if it's true, if you're taking hydrocodone and you don't have a prescription, you both have a legal and a controlled substance problem. You probably need to check both of those out.
Yes.
I'll see you July the 6th. I'm gonna drug test you again. All right, you're free to go, sir.
Thank you.
I'm not gonna wait around and have it here. It's too late in the day. He lucked out. Is that everything? Do I have results on Mr. Webb? Who is that? Is that Mills? We're gonna have to tell Mr. Mills that he's gonna have to be available if he's got people that still have drug tests out. Can I see Mr. Webb's docket sheet? Is this first time test? I know, I'm just seeing if it's his first time. No, Webb. I got it. We know, Mr. If he's still going to the back. Yes, sir. I might be calling you back. Yes, sir.